judges have been told they must consider more lenient sentences for those from underprivileged backgrounds. The new guidelines aim to improve fairness by addressing disadvantages relating to upbringing and personal circumstances, which could increase the likelihood of a person committing crime. But critics have called the changes unjust, with Justice Secretary Alex Chalk branding them as patronising and inaccurate. Joining us now is James Rossiter from the Criminal Bar Association. What do we just give you a broad brush view to begin with, if we can? James, what's your thoughts on this?
Well, I think the first thing is to say that judges already have these guidelines, and to be fair to the Sentencing Council, they undernerred but wanted some sort of consistency out there, so there was no disparity between the considerations that are already taken into account by judges. And I think the first thing to remember is that judges should be trusted. They really do put into custody those who are a danger to wider society, and then they take everything else into consideration. So I think we should just trust judges to do the right thing. But I think it's very important to recognise the optics on this. They just don't look great. If it appears that people are being soft on those who come from perhaps disadvantaged backgrounds. But the reality is that doesn't actually happen when judges make sentencing decisions. They think fairly, and they put away those that are dangerous into prison, and they can get the rehabilitation services they need, so hopefully they don't reoffend. But the big picture is this, is the fuss and focus on this in the week that we are now have the evidence of the biggest case backlogs in history in 23 years. They slipped out last Thursday. There's 67,500 cases waiting to be heard in our Crown courts. That's more than doubled in 5 years. The magistrates have 380,000 cases, according to separate figures that came out the week before. That's the end of January. They're up 40,000 in a year. And the reason this matters is that we have simply run out of people to prosecute cases. It's unheard of that you turn up to court and you might have been waiting 2-3 years for your case to come to trial after charge, and then there isn't a prosecutor in court that day. It'd be like turning up to hospital for open heart surgery and being told, sorry, there's no surgeon there. There'll be an outcry. So we feel that the focus on, frankly, quite insignificant in the relative scheme of things, sentencing guidelines, which judges already know, is a huge dead cat to distract what we should be talking about, with the fact that there aren't cases coming to court, and when they do come to court, there aren't enough barristers to prosecute and defend them, let alone judges. I'll leave you with another thought that your listeners and viewers may want to think about. We're supposed to have our courts open every day. We don't have school holidays. It's like going to hospital. For the 4th working day running, we've had over 1 in 4 of our Crown courts shut. The MOJ will tell you, as they've told us repeatedly for the last few months, that we're running the courts at full throttle. Well, we're deoxygenated, we're running on vapours. We simply don't have enough people there. I was down, if you don't mind me going on, I'll show you why it's so important. I was down in Maidstone from doors opening at 8 o'clock till 7 o'clock at night, a week last Monday. Going from court to court, went to 8 different courts just to get a taster so we knew what was happening on the ground. A call came through at 9 o'clock in the morning. Barristers were being there, a dozen of them, waiting to prosecute and defend an array of cases from rape to attempted rape to a murder of a convicted paedophile, all sorts of pretty heinous crimes that you and I would expect to be dealt with. And a call comes through at 9 o'clock on the Tannoy, say, is there anyone free to prosecute a trial? It's unbelievable, but that happens now on a daily basis. There was no one free. There was a deal done by a prosecutor who was there to prosecute a serious road traffic accident, causing death by causing serious harm by driving. The complainant was disabled, had come all the way to court. They'd waited a couple of years for their trial. It was on what's called a BACA. That was to say if there was court time, they'd slip him in. The deal that was done at 1 o'clock with one of the judges in the court was that we'll try and hear your case, this poor complainant, remember, waiting, disabled, if you take on the case that's before that. He'd never seen it. He had 1 hour to prepare it at 1 o'clock. At 2 o'clock, I watched him scroll through the laptop in front of me as he tried to prosecute a man who was accused of theft, had 25 previous convictions. The victim was an 85-year-old woman with dementia. The judge was furious that the CPS, the instructions given to that barrister, the CPS was only going for what was called a category a 3 sentence, not what the judge said should be category 4. It means how much longer you should be in custody. And he was livid. The poor barrister couldn't do anything. He only had instructions that day. And the judge rightly said this is inadequate from the CPS. But what are the CPS to do when there aren't enough people to prosecute? Now, you may think I'm making a political point here, but it's just a fact that last year, for example, we had over 750 trials of all offences adjourned on the day because there's no prosecutor. That's a 40-fold rise, 40-fold rise from about 19 or so that happened similarly in 2018 and 19. It is just unheard of. So that's a long preamble. Just gives you the context of why really should we care about these sentencing guidelines? They're interesting. It's important that there's consistency, but it's an enormous distraction from the frankly broken justice system when no one's seeing justice at all.
Yeah, I mean, you've given some great context and background as to where the real problems are in the judicial system, and this clearly isn't really top of the list. Just in 10 seconds, if you can, James, because we are short of time, and thank you for that very thorough answer as well, and the backstory of what is really going on in our courts. And but in terms of this disparity between how sentencing works dependent on your class, is there any real evidence to say that somebody caught shoplifting who earns £100,000 a year and works as an accountant will be treated more leniently than somebody who is unemployed and gets caught shoplifting?
No, and the evidence is the contrary. Funny enough, I've just been on by the seaside this weekend, met a friend of mine who's a former accountant, has just been is serving time at an open prison around the corner in Suffolk for fraudulent accounting. And from memory, he was given 7-year custody sentence. He's 70. And one of his colleagues is 80 and he handed 5 years. They are clearly middle class. It was well off. And they fiddle the accounts, apparently, and they'd be convicted and sent to prison. It might be an open prison, but convicted. Yep. So there isn't the evidence that that is the case. Look, I can tell you, because you can't tell perhaps by my shoulders now, they're a bit screwed up, but I still play rugby. I'm well over 50. I play against Feltham open prisoners once a year, a rehabilitation case program where they whack the living daylight out of us and we try and give them rugby values. And every single one of those young men who are pretty angry, who's banged up, come from pretty poor backgrounds.
Right. So no tangible evidence that there's this huge chasm between the two.
Not at the moment.